So with that, I want to say good afternoon and welcome to EMSDC's webinar on strategic partnerships and joint ventures and the value of them. We are very, very fortunate to have with us Mr. Bernard Williams. He is Esquire. He is an entrepreneur and business leader and an attorney who has represented many business owners for the last 18 years. In 2016, Bernard formed Company Counsel, LLC, after seeing too many small business owners struggle because they did not have access to quality legal advice and counsel when it was needed. Too many business owners were filing for bankruptcy, losing money and sleep, or feeling stress and uncertainty as they worried about the future of both their businesses and their family. Today, as a managing partner of Company Counsel, LLC, Bernard focuses his legal practice on helping small business owners beat the odds, make better decisions, and grow companies that impact the world. Every big corporation relies on in-house counsel in support of its operations, risk management, and growth. Company Counsel provides the same type of general counsel legal services to small companies scaled in a way that makes sense for them, and in the critical areas of business law, HR, employment law, and intellectual property. Before forming Company Counsel, Bernard was a partner in the Philadelphia business law firm's Legis Group. Before joining the Legis Group, Bernard was the owner and general counsel of an education company that specialized in academic tutoring and test preparation. Prior to that, Bernard was a senior associate at Drinker, Biddle, and Reith, LLP, located in Philadelphia, where he served as lead litigation counsel for businesses in the greater Philadelphia area. And prior to that, he was an associate at Dickstein Shapiro, LLP, located in New York, and at Cravath, Swain, and Moore, LLP, also in New York. Bernard received his law degree from New York University School of Law, that's where I want my daughter to go, where he served as an editor on the NYU Law Review. Bernard serves as president of the board of directors of the Business Center, a nonprofit focused on helping people start, sustain, and grow businesses in the Germantown community. Bernard regularly speaks on publicly on a variety of topics, including entrepreneurship, networking, professional development, and small business legal issues. I am so excited to have you here today, Bernard. First of all, your affiliation with the Business Center is really how we've amplified our relationship. Of course, you're certified by EMSDC. And, you know, as I say to every certified business, I only know you in context of your certification until we have that opportunity to get to know each other. And so fortunately, because of the partnership that EMSDC and the Business Center are working on right now, we have had an opportunity to really get to know each other, to understand the services that Company Counsel provides, that you provide, and also how there may be some opportunities to bring these important topics to our minority businesses. And today, we're going to talk about strategic partnerships and joint ventures because we're in tumultuous times. Many businesses are struggling to stay afloat. They're trying to figure out how to scale and grow in uncertain times. And one of the things that we have learned is that through strategic partnerships, you can potentially increase capacity and also expand business opportunities for your companies. And so with that, I'd like to just start off with, from your, no, not from your vantage point, what is a joint venture and or strategic partnerships from a legal definition?
That's a great question, and thank you for the awesome introduction. You're right, by the way, listening to your own bio is a bit awkward. But now that that's out of the way, we can get to the reason everybody is here. So you're right to identify joint ventures as one of the types of legal collaborations that you might be able to form, but it's not the only one. There are a lot of different ways that you can collaborate, either individual to individual or company to company, and lots of different ways that you can structure that depending on the needs and what you're actually trying to accomplish. So what I always do is, oftentimes I find that because I'm an attorney, people will come to me too late in the process. They'll come to me after, in their view, the deal is done and they just want me to give them the contract. But the reality is that I can provide the most value if I start much earlier in the process, if I start with at the very outset. And the first question that you ask, in my opinion, and in my experience, is not what type of entity do you want. The first question is why do you want a strategic partnership in the first place? And even more specifically, why do you want a strategic partnership with this individual or this entity? It's a little bit like in your personal life, the difference between saying, I want to get married one day and saying, I want to marry this particular person. Whatever you enter into, any sort of a strategic partnership, you want to make sure that there's a specific reason and a specific goal or purpose that you're trying to achieve. And just as important, that particular partner is the right one to help you to get there. If they're in the right industry, if they fit the right professional category, but it's not a good personality fit, then it's not going to work. And it really doesn't matter what type of legal structure you have if you haven't found the right strategic partner to begin with.
So what are some of the questions you need to be asking as you are trying to determine if this is a right fit? I mean, and I'm going to go back to, the project that we're working on together right now is, you have two friends coming together, forming it, doing a partnership, very, trust each other. The trust is there. So how do we ensure that, number one, that we're aligned from a business perspective? We know we're friends, but how do we assure business alignment? Number one, how do we ensure that the friendship lives beyond the partnership?
Right.
Number two, and number three, how do we structure an agreement or a partnership that will allow us to build on the core competencies of each individual entity?
Right. First of all, you're right to be asking these questions because I think the trap that a lot of us fall into is to say, I'm going to be working with my best friend. And we've been, through thick and thin, we've been through it all, and nothing's gonna separate us. So we don't need to worry about all this stuff. We'll work it out. That is almost always a recipe for disaster. So I applaud you that even though this is your friend of many, many years that you're going to be working with, that you're asking these questions. I think the right way to have the conversation, I should say, one of the ways that I suggest to have the conversation is for each of you to do your own homework first, and then to come together to talk. And what that homework looks like is to just get out a sheet of paper and a pen, and for yourself to jot down what your interests are in this partnership. In other words, what is it that you're hoping to get out of this? And then in a column next to that, write out what are her interests? What do I think she wants to get out of this? And beneath those, the next question you want to address is, what do I expect to contribute to this partnership? And then after that, the corollary question is, what do I expect my partner to contribute? So if both of you answer those four questions privately, and then come together, you can have a really robust conversation about what your expectations are and what you hope to get out of this in comparison with what the other person does. And that's a really good place to see if you're way off. And if you are, then that's a signal that either you need a lot more conversation or that it's maybe not the right strategic partner. Or maybe you're not way off, maybe you're in the ballpark, and now it's just a matter of negotiating around the differences.
And so as you're working through this, and I think this is really important, I think businesses in particular enter into these strategic partnerships not clearly defining what their expectations and desired outcomes are. And so once you've gotten to the point where there's alignment, how do you assess what is the best type of structure for the entity that you're looking to, or the partnership you're looking to create?
Right. So So that question can be answered after you've had that meeting to compare your interests and their interests and your expectations for each. Because at that point, there likely will be some things that come out of that meeting that'll give you targets in terms of what to aim toward. And once you have those targets, that'll dictate what type of entity to form. So I'll give you an example. There are two attorneys, each of whom own their own law firms, are thinking about forming some sort of a partnership together. But there's a few different ways that they can do it. They can, partner A, we'll call partner A Amy and partner B Ben. Okay, Amy could join Ben's firm as an individual, and could either be, and then that relationship can either be an employment relationship or an independent contractor relationship, or maybe she can even buy into Ben's partnership, and they would be partners within Ben's firm. Alternatively, if they want to work together, they could do the opposite. And Ben, as an individual, could leave his firm and go and become either an employee, a contractor, or a co-owner with Amy. That's one way to do it. Alternatively, they could decide. Amy could decide. You know what? Amy and Ben could both decide to combine their companies, and now they have a combined resultant company of Amy and Ben LLP. Or one company could buy out the other. Or there could be, they could form a joint venture, which is technically a third company that both companies, that both Amy's and Ben's companies are jointly operating. The way that you choose from all those options, and I probably just rattled off, 21, 30 different options. The way that you choose from among all those options is what each of the constituents wants, is by looking at what each of the constituents wants to get out of the deal. So if it's really important for Amy to retain majority ownership in a company, then her becoming employee in Ben's company isn't going to work. So you can cross off that option. If there's something in a partnership that they're trying to achieve that can best be accomplished not in either one of their existing companies, but through a third company, then a joint venture would make the most sense. And that's a scenario that I think you're in, where your entity wants to combine forces with another entity to do something that's completely different from what either one of you are doing, and both of you want your existing entities to continue to exist, right? So in that scenario, you choose a joint venture. The point here is that depending on what your interests are and what you're trying to accomplish, there are different vehicles that you can use to accomplish whatever that is.
And so what I'm seeing, and I appreciate that because you've been guiding us on this. What I'm seeing also from our diverse businesses, from our MBEs, is that more and more the conversation around strategic partnerships, strategic collaborations, joint ventures are coming up. And a couple of things, for certification purposes, in a joint venture, the minority partner has to be certified. And if the joint venture also is seeking certification, the minority partner has to retain control inside of the joint venture. So it's a two-pronged process when it talks about certification. But if you take certification off of the table, what is some of the best advice that you can give to business owners, number one, on the value of these strategic collaborations, number two, on the best way to structure them in order to maintain autonomy, particularly as it relates to certification, and also in terms of financial stability? Because I think that's a lot of what everyone is looking at. How do I pursue my next opportunity? I don't have the bandwidth anymore because of the shrinking economy to do what I may have done in the past, and now it's time for me to look for a partner. what's the best way for me to move forward with my company in these types of scenarios?
Um, so, so in this scenario, have we already identified the partner and we figured out the why and what we're trying to accomplish? So once we know what our interests are and what we're working toward, that is the right time to get into some of the logistics, some of the difficult questions. For many people, talking about the finances is one of the most difficult parts of this. Lots of us have sensitivities around it. But the reality is that in the business world, it's literally the currency of what we're dealing with. So when you have these financial conversations, you want to be aware that this power / decision making and ownership interest and compensation are not all necessarily equal, and are not all necessarily treated equally. So there could be scenarios where one person may have more power in a partner than the others, but the others have greater compensation. So when you're doing your negotiation, you want to balance out the interest in decision making and authority, actual ownership of the company, and the financial pieces. Now, in order for any company to operate, it's going to have to have some sort of capital. So for either joint ventures or for partnerships, typically the way the ownership interests are divided by default is that if I put in half the capital and you put in half the capital, then I'm a 50% owner and you're a 50% owner. Then you're a 50% owner. But it doesn't necessarily have to go that way. You can divide up the ownership interests and the capital, the capital. I can't think of the word, infusion, differently depending on the situation.
So in those instances, so we've worked out the financial structure of it. One of the questions is sometimes financial capital infusion is not hard cash. It's in-kind services. It's subject matter expertise. It's access to business opportunity. And so how do you quantify that in terms of structuring the partner? And are there downsides to relying on that as a primary basis of setting up your business or your joint venture or relationship, as opposed to coming to the table with a equitable cash contribution?
Yeah, so on paper, it's easiest to divide up if everybody is literally paying for their equity interests if they're buying in. But if they're not using cash to buy in, you still have to technically buy into a partnership in order to become an owner. However, it doesn't necessarily have to be with cash assets. It can be with, quote unquote, sweat equity or other things that you bring to the table. The question of how to value that is a lot trickier and more subjective, and that's part of the negotiation. And a lot of times, but it's an important question to answer up front, because if you haven't talked through that up front, then it's the kind of thing that can lead to conflict down the road. So in other words, the scenario that I've seen is one partner puts in most of the money, but does none of the work, and the other partner puts in almost none of the money, but does all the work, and each of them ultimately feels like they're getting the short end of the stick. So in order to avoid that scenario or to lessen the possibility of that scenario, you want to have clear conversations from the beginning about what's expected and what the value of everybody's contributions are. And then if there does emerge a problem, one of the other things that I've seen over time is that in a partnership, if any one partner has an issue, then the partnership has an issue. So because even if that person or that partner, that company doesn't say anything at first, problems have a way of festering and building up beneath the surface, and they ultimately will come out. And avoidance of a business problem like this typically results in a much bigger problem down the road. So rather than letting things fester, if you're aware that any partner has an issue down the road after an initial partnership agreement has been entered into, if down the road any partnership, or rather any partner has an issue with how things are split, how things are divided, then it has to be addressed. It doesn't necessarily mean you have to throw away the contract and start over, but it at least has to be addressed before it builds into something much worse.
So it's interesting that you used that. You addressed the issue of valuation and two issues: valuation and problems. So I want to ask the first one, and then after you answer that, I'm going to try to remember to ask the second piece of it as well.
Okay.
In terms of valuation, that becomes very tricky, particularly when you look at certification, because we're evaluating ownership and control. And of course, to your point, the easiest way to evaluate ownership is cash contribution. Is everyone coming to the table with real cash that they're contributing to the entity? When there is disparity in cash contribution versus sweat equity, it is very difficult to value that. And sometimes it distorts the perception of ownership by the non-cash contributing partner. And in this instance, for certification purposes, it's the minority partner who may be coming with sweat equity as opposed to the cash contribution. How do you address that up front, number one? Because if you're seeking certification, it needs to be addressed. It needs to be dealt with, because during the review process, you can't undo what you've already agreed to and submitted for certification. So how do you as an attorney address the apparent, and I'm gonna use the words apparent, disparities between cash contribution and sweat equity in an agreement to ensure that it's clearly communicated that although no cash contribution, the sweat equity has real value?
Well, so depending on the type of entity that you're talking about, there are different places that you would look to find out who the owners are or who the partners are and what their relative interests are. So, for example, if it's let's say that it's a joint venture, Amy and Ben come together and they form a joint venture. It's a separate entity, and they want that joint venture to be structured as an LLC, which stands for Limited Liability Company, right? Amy and Ben would be the members of that LLC. And when the LLC is formed, there would be a governance document, in this case, an operating agreement, that would set forth what all the interests are between the two. So it may or may not give you the amount that either has contributed, but it will give you the amount of interest that they have, and that agreement typically will say that interest has been either paid for or deemed paid for, and once that agreement is executed, that will be the evidence of what the representative interests are. In other cases, so an operating agreement is used for LLCs. Bylaws would be the equivalent for a corporation. Partnership agreements for partnership. Yeah, I think those would be the ones you see most frequently.
So what I'm hearing from you is that inside of the operating agreement, the structure of that agreement would define, although not directly, the value of the sweat equity and cash contribution. So even though sweat equity doesn't have a monetary value per se, based on the structure of the operating agreement. You know, what member is the managing member versus the subordinated member. That would allow you to see what potentially would be the value of the sweat equity.
Yeah. So the operating agreement wouldn't have the overall value. It wouldn't have the valuation of the company.
Correct.
Right. That's something that's a moving number. So you wouldn't know what the value of you couldn't tell just from the operating agreement what the financial value of somebody's interest in the company would equate to. However, if you look at the ownership of the company as a pie, you can by looking at the operating agreement, you can tell what percentage of that pie each member is entitled to.
Correct. And you said it much more eloquently than I did. But at the end of the day, the operating agreement is the governing document for the partners or for the entity, and will define control inside of that operating agreement.
That's right, and I think I said this earlier, but it's important to note that ownership and control are not necessarily the same thing. By default, they typically are, but that's not necessarily the case. And you could have a scenario where, particularly in an LLC operating agreement, you could have one person who or one partner or one member who owns most of the company and has very little managerial responsibility or decision-making authority, and another who owns less of the company but has more decision-making authority.
So let me clarify, though, for anyone who's listening, for certification purposes, ownership and control are the same thing. They're not separate. For certification purposes, a business must be owned and controlled by the minority partner. So I want to, I understand from a legal perspective, someone can own it and not be responsible for the day-to-day operations and management and control. But for certification purposes, those cannot be separated. So just want to make sure anyone out there listening, I don't want you to come back and say, well, Bernard said.
But I'm glad that he said that, because in every scenario, no two scenarios are the same. And I always caution people to, from getting templates online or from following the advice that their cousin did in a different city, in a different scenario. Every scenario is unique. So if certification, if you need to be certified, and if that's something that's going to be important to your business, which I'm sure for many of the people in this audience it is, then you're right. You're not going to structure it in the same way that somebody would, where certification maybe isn't an issue. Because for somebody that doesn't care about certification, they can, there's some maneuverability there with the ownership and the control. But for somebody who does want the certification, you need to be careful not to structure it in the way that other person is. So I think that goes back to the point that these really are not cookie cutter arrangements. It's really important to think through what the purpose is and what the unforeseen consequences may be of particular decisions as you plan.
So there's a question, and I'm going to ask your question, Prasad, but let me ask this other question. As you're defining, because I want to remember it while I can, I'm at that point in my life. As you're defining partnerships or you're bringing two entities together, one of the things you referred to were problems. And the problems that you were referring to, as I understood them, were if you have one dissatisfied partner in the entity in terms of the structure of the entity that has not revealed their concerns early on. Right. But how do business problems, a business that may have financial issues or, customer experience issues, insurance issues, HR issues that are independent of the entity, but one of the two may be dealing with some legal challenges. How do they impact and how do you mitigate their impact on this newly formed partnership if they're not revealed up front?
Hmm. Well, one of the things you can do is when you're forming your joint venture agreement or your partnership agreement, you can address removal or termination of the agreement, and you can include certain things that would trigger automatic termination, or at least the right to terminate the agreement. So, for example, what a lot of contracts will have is something that says something, and I'm paraphrasing, but something to the effect that if you do something illegal, or if you do something that's going to embarrass me or this joint venture, then I have the right to kick you out. So baking that right into the agreement itself, into the governance document, is an important thing to do so that you can exercise that right later on if you need to. Another thing that you can do is there's a concept of indemnification, which is related to this. All right, and indemnification means to stand in for or to pay for the debts or liabilities of another person or entity. So in other words, if one of the partners is sued or incurs some sort of liability because it's something that they're doing for the partnership or for that joint venture, then oftentimes that partnership or joint venture will indemnify, or that is stand in and protect the partner. So if you want to have indemnification for either of your partners, then that's something that will go into that original document as well.
So, couple things. I don't want to talk. I don't want it to feel like we're just talking about the downsides and the struggles of putting together partnerships. Can we talk about some of the inherent benefits of strategic partnerships, collaborations, and why as small businesses, we really should be exploring these types of partnerships to help grow our business?
Sure. Well, there's lots of reasons, and I think we may have talked earlier about the fact that there's a lot of activity right now in the small business community around collaborating and strategic partnerships. It's difficult out there. It's a hard economy, and any way that we can join forces to make money and save money, we should be exploring. So some of the reasons to join forces and to build strategic relationships, rather strategic partnerships, are so that you can expand your market share, so that you can diversify and offer different services. For example, I've recently worked with two different companies. One was a veterinary practice, and the other was a dog training service. And they formed a joint venture together, or rather a strategic partnership together, so that a patient, I'm not sure what you even call somebody who goes to a client,
The dog,
patient. The dog's the patient there, right?
Yeah.
All right. Well, whatever. This family would go to the vet for medical help, veterinary help, and then be referred to the dog trainer, and vice versa. So that was a way that each of those partners formed a strategic partnership in order to provide better service and more holistic service to their clients and patients, as well as to provide access to new consumers, new patients for themselves. Sometimes it's about relationships. There are strategic partnerships where maybe an alumni association will team with the benefits, a company that provides benefits because they can help each other. One company wants to have access to people that want to buy from them, and the other may have that interest in providing membership benefits to their members. There's just there are limitless ways. The more creative you get to join forces in order to gain exposure, to open up access, and to make more money. On the other side of the coin, you can also use strategic partnerships to save money. For example, there are a lot of companies in the same industry who might pool together in order to buy products, because when they do that, they can buy those same products they're going to buy anyway at a lower price because of the volume discounts. So you hear about that a lot. You hear about maybe associations forming of companies in order to gain access to better insurance benefits or better rates for particular things. If you have two dental practices could come together and hire one marketing person to handle the marketing for both of them, thereby saving costs on marketing. You could join forces and both operate out of the same space and thereby save money on real estate and rent. So just as being creative can unearth lots of different ways that strategic partnerships can help you to make money, being creative also can help you to unearth a lot of different ways that using strategic partnerships can help you to save money too.
And what I hear from strategic partnerships and collaborations, or from what you just described, as opposed to say a joint venture, is it's not necessary to come together and form another entity. You're not commingling. What you're doing is sharing. You're sharing resources and services and clients, or you're sharing consultants and things that can benefit both. So there's some inherent advantages to, that structure, as opposed to if you're pursuing a business opportunity where it's a need to come together as a joint venture and form a separate entity. Are there ever times you can pursue a business opportunity in a strategic partnership relationship that doesn't require forming a joint venture?
Yeah, so a strategic partnership it's really just a term of art that encompasses lots of different types of arrangements, including joint ventures, and or it could be contractual. It could be company A and company B decide to form a contract to work together without forming that separate entity. Yes, and that goes back to why I think the place to start is asking why and what you want to accomplish, and looking at those answers will help you make some decisions about whether or not you need to form a different entity, or whether it's better to form some sort of contractual relationship between the two parties.
Excellent. So I have a couple of questions. I would invite anyone who has questions to please put them in the chat. But one of the questions goes back to the conversation around sweat equity and how do you define it? And how do you calculate it in terms of a partnership? How do you compute sweat equity in a partnership, and how do you define its value?
Yeah, so that's I'll be quite honest. That's probably a better question for a tax accountant than for me. What I can tell you is, well, the important thing is for there to be an agreement on what the value of the sweat equity is, and if there's not an agreement, then that's where the trouble begins. So in terms of reaching the agreement, some of the ways that one of the things you could do is to look to the industry and to determine whether or not there are any industry norms for what the value of particular services would be. So that's one way. It's not definitive, but that's one way to at least get into the ballpark of what certain services are worth. If there is, so we haven't talked about intellectual property, which is my fault waiting this long into the program to mention intellectual property. But IP can be a crucial element to strategic partnerships generally, and joint ventures in particular. Intellectual property is the umbrella term that covers any rights that you have to something that something that's intangible, usually something that you've created. So, for example, if you've invented a product, if you've invented really anything, then you may be entitled to patent protection. If you have a logo or a slogan, then those are brands that are protectable by trademarks. So sometimes what you're bringing to the conversation is it's less about the actual services you're providing and more about the intellectual property and the value of that intellectual property. But there again, actually getting into the nitty gritty financial and mathematical detail of what a service is worth or what the IP is worth, that's a little above my pay grade. It varies. But you do want to think about the value of the IP and the value of services and anything else that you bring. If you're not able to bring actual cash contributions to buy the partnership interest.
And that's important because I don't think that we oftentimes think about that as a value add to any partnership that we bring to the table. And so what we will do, however, is because it's above both of our pay grades is, maybe loop a tax accountant or, a CPA into this conversation. That's when they talk about valuation, we always got to bring the money person into the conversation. I have two additional questions. One is not necessarily related to the topic, but just they said, want to take advantage of this opportunity to find out what are the pros and cons of using a DBA in business.
Sure. Well, so DBA stands for doing business as. And in Pennsylvania, at least, that's it's called a fictitious name. In most places, it's called a fictitious name, and basically, what it is a nickname for your company. So every company, once you're legally formed in a state, you have a legal name. In my case, it's company. In my firm's case, it's Company Counsel LLC. And I do business, rather my firm does business using that legal name, Company Counsel LLC. But if I chose a different legal name that I didn't want to use as a trade name, for example, Bernard A. Williams, the law offices of Bernard A. Williams, I could have done a fictitious name registration in order to be allowed to do business as Company Counsel. So to summarize, if you want to use your legal name, whatever you registered your company as, then you don't need a DBA. You don't need a fictitious name registration. But if you register it as one name and you essentially want to use a trade name, which is kind of like a nickname, instead of your legal name in the marketplace, then that's where you would use the fictitious name registration.
And is there any pro or con to doing it either way?
If you're buying into a franchise, then you have to use a fictitious name registration so that you can do business as that brand. Or in similar situations, if there are lots of different legal entities that all want to operate using the same brand, then that's a situation where the fictitious name makes sense. Or if you started a company maybe for one purpose and the purpose has changed, and rather than changing the name of the company, you want to just change the trade name, you can do it that way. Or if you want to market to different markets, the Company Counsel Philadelphia, the Company Counsel Bucks County, Company Counsel Montgomery County, whatever, and all those can be tied to the same legal name.
So I think in the case of EMSDC, one of the things that we had is because we went through multiple mergers, our legal name is different from EMSDC. So EMSDC is actually our DBA, whereas our legal name is something else that I can't tell everyone. No. No, our legal name is just the last standing of all the merged companies. It's the oldest of all the merged companies that eventually became the entity that is now EMSDC. But absolutely understand that. So I have another question around strategic partnerships. And Eric says, thank you for that answer. One of the issues in strategic partnerships is building a real working relationship among the partners. How do you do this effectively?
Well, I think it comes down to two primary things. One is communication, and the other is relationship building. So the communication starts from the very beginning, and it starts with that open and honest conversation about what each of the partners expects and what each of the partners will be contributing. And that's a really good opening to have a conversation about accountability and metrics. How are we going to know if this is working? How are we going to know if I'm doing my part? How are we going to know if you're doing your part? So that, so the accountability of metrics can be defined from the beginning. And once you once you had that figured out, and once you have a lot of these details that you've agreed on, you want to start thinking about that legal agreement as early as possible, and eventually get to a point where what you're agreeing, including the accountability and including those questions about how we know if this is working, all of that should be baked into whatever legal document you wind up signing. And then that can be what, and then that's what you use as almost like a constitution moving forward to evaluate things and to fix things if things aren't going the right way. So I put all that into the context or into the category of communication. It's talking through what makes sense for your company, and then agreeing on that, and then putting it in writing so that you can go back and look at it and evaluate it later. Now, in addition to that, the best contract in the world will not take the place of emotional intelligence and the ability to work in an environment with other people. There always are going to be skills that you need to bring to the table that are independent of whatever is in the contract. So I can write a contract that dictates what happens if the parties don't get along, but I can't write a contract that forces the parties to get along, right? So in addition to the communications, it's important that I'm a big believer in constantly educating myself about how to interact with others, interpersonal dynamics, how to negotiate, how to communicate, having a constant conversation around those topics, and those constant ongoing conversations, learning opportunities, tend to lend themselves to opportunities to fix problems collaboratively. But I think ultimately you need both. I think you need to have the structure of the contract that reflects the what you've communicated and about accountability. Then you also have to have the ability to actually have a conversation with your partner to work things out as they come up. Does that make sense? Does that answer the question?
I think at the end of the day, you have to have two mature entities coming to the table committed to building a strong relationship. That's what I heard.
Yeah, you heard the contract part too, right?
Yeah. I always hear
that.
Okay. So I do have another question, and this is because we have a number of corporates on the call, on the line, and I want to kind of flip it this way. How do we or how do corporates encourage minority businesses to form strategic partnerships, alliances, joint ventures, whatever collaborations, in order to better serve them in their supply chain needs? I mean, I think that one of the things we deal with is capacity. So basically, how do we use these partnerships, these relationships, to build capacity to support the sourcing needs of our corporate partners?
Yeah, I think this week is a good opportunity for that. The Matchmaker is a great opportunity to develop relationships, make introductions with other people that and other companies that may be aligned with our and that I think is the beginning of opportunities to collaborate toward building, rather toward increasing our own capacity. Another one of my clients he's an IT professional, really, really good at what he does. He's in managed services, and he's highly sought after. But the problem was that he couldn't serve larger clients because he was only one person. So it wasn't until he collaborated, he formed a joint venture with another IT professional that does the same thing, that he was able to start bidding on larger projects and getting projects that had a larger profit margin and that frankly were more interesting to him. So yeah, it's absolutely, if you're able to identify through this matchmaker program or otherwise opportunities to form alliances to increase your own capacity to serve larger projects and larger clients, then I think that's a great reason to form alliances.
Well, I just want to thank you for this conversation. I think that it is something that has to be ongoing. We need to look at this in terms of building capacity, of, to your point, saving money and making money. And also as we look to those businesses that are in the legacy phase of their companies, and how do you move to the next level in terms of planning your legacy, of offboarding. And so this is a conversation that won't stop here. Bernard, you're certainly going to be invited back to continue to give advice. I love that Company Counsel is around to support our business owners like as if they had in-house corporate counsel. And so I would encourage anyone to check out Company Counsel. You can tell the website, I don't know it off the top of my head. But
sure. May I? It's companycounsel.law, COMPANYCOUNSEL.law. And listen, so I know we talked about a lot of things today, a lot of options, a lot of things that you want to think through in the planning stage. If anybody needs a planning document, a checklist to actually work through these things with your prospective strategic partner, just shoot me an email and let me know that you want the checklist, and I will get that out to you. My email address is bwilliams@companycounsel.law. And right. I'll put that in the chat.
I was trying to do it as well. I'm not as fast. I was hoping that Meg would beat me to it, but I think I got it, Meg.
There
so
you go.
That, we're at 12:58. Yeah. Do you have any closing words that you want to say before I let you go? I really appreciate you taking this time. This has been a really good discussion. It is coming up more and more. And so we need to make sure that we're having these timely conversations. Yes, this is recorded and you can find it on EMSDC's website and on our YouTube channel. Give us about, I would suspect, give us till end of day to get it up on online. But Bernard, I'll give you the final words as we depart.
Oh, thank you, Baylor. This was a lot of fun. This is one of my favorite topics to talk about. Because there are just so many opportunities once you start thinking about it. In so many ways that collaborating can increase our bottom lines. We can make more money, we could have more fun, we could have a greater impact, we could save money. So there's lots of reasons to do it. There also are a lot of red flags potentially, and it can be a minefield, so it has to be done right. And the right questions have to be asked. So I think it's really important to have this conversation, identify what some of those questions are, and hopefully lay the groundwork for a really successful 2021. As I said, I know we covered a lot of things today, and because of the nature of this conversation, it had to be a little bit high level. In every case is specific. So if anyone has any specific questions about their scenario, or if anybody has an interest in receiving that checklist that I mentioned with the conversation topics to work through in your planning meeting, then please shoot me an email. Otherwise, Valerie, thank you so much. It's always awesome to talk to you, and I appreciate the opportunity.
Thank you so much. Everyone have a great day. Be well, stay safe, wear a mask. It protects you, it protects someone else. Bye-bye.
Bye.